To order.
Right, the record reflect we are back in session. Parties in council are present. Our jurors are not present. One of the jurors called in this morning and indicated that he had taken his wife to the hospital with chest pains and was there with her now and would not be here today. And since we were not going to be in session this afternoon for another juror's medical appointment, we just called off the jury for today. Hopefully that juror will be back tomorrow. If the juror is not available to return tomorrow, then we would probably go ahead and excuse that juror.
Sorry, I may have missed it. Did you identify which juror that was?
It was one of the alternates. I don't know which one it was.
5.
Alternate number 5.
Same one that broke his arm.
Is that right?
Wait, say
No, that's 4.
Alternate one that broke his arm.
No, it's alternate number 5.
It's
Different one.
older gentleman.
Yeah, the submarine.
Okay. So we'll see where we are with that tomorrow. But obviously, if the situation is he's not going to be able to return tomorrow, then we would probably go ahead and excuse him. There was the defense had filed a motion on yesterday? Yes, yesterday to exclude jail conversations that the defendant may have had with either friends or family members that were recorded while he was in custody. The people filed a response to that today. So are council ready to proceed on that?
Sure. Yes.
Okay. So, did you wish to be heard, Mr. McGee?
I think first there'd have to be some evidence before the court, so the court can understand the entirety of our complaint. And to satisfy that, we have to call Sergeant Ryan Smith
For what issue?
for the issue of whether or not the Sheriff's Department has been listening to these calls and providing that information to the DA's office, if they have been listening to those calls before this date of event. Because if they have, and they have been in constant violation of 1054.1, which requires the immediate turning over of all statements of the defendant, not just the ones they want to use. And that tactical evasion of providing that information so we can correct the actions of our client, to tell them to stop talking about a case, could take effect. By keeping that information from us would be a tactical decision to make sure they can keep eavesdropping on statements of our client without informing the defense that they have such information. So I want to get to the extent that they were listening to him and how long they knew, and then what decisions were made as to why it was not turned over as required, immediate disclosure of those statements under 1054.1 and .5.
Okay. So you can call Sergeant Smith. No, he didn't need this one. He's still under oath. You're reminded you're still under oath.
Sergeant Smith, you're the investigating, or the case agent for the matter of People versus Charles Merritt.
Yes, sir.
And as part of the case agent, is it part of your duties to oversee the investigation in its current state as it progresses through trial?
I don't know that I would characterize it as oversee, but yes, I'm the liaison between the Sheriff's Department, Homicide Detail, and the District Attorney's Office.
And you are sitting as the investigating officer during the trial, all days you're available?
Yes, sir.
And at some point, did you learn that the Sheriff's Department has phone calls and audio recordings of visits or conversations with Mr. Merritt between other members of his family, friends, people outside of custody?
Yes.
And when did you learn that the sheriff's department was obtaining recordings of such conversations after trial began?
Objection vague.
Overruled.
Your Honor, if I may be heard, why that question is vague?
Okay.
Because the jail, as a matter of its normal policy for all prisoners, records all conversations made on the telephone, and therefore, whether or not their access is different, whether or not they are utilized in any way is different, given the thousands of inmates that go through the jail system. So, in that sense, the question is vague and overbroad.
Overruled, you can answer and explain.
Can you repeat your question?
Did you become aware that the sheriff's department personnel or district attorney personnel were reviewing any recordings of conversations of Mr. Merritt after the trial began?
I'm also gonna object.
Sustain is compound.
And I just wanna note the focus of the people was on one particular visit. One particular visit.
After the beginning of trial, did you receive any information that sheriff's personnel were reviewing any conversations involving Mr. Merritt?
Yes.
And what date did you first receive notice that conversations with Mr. Merritt were being reviewed?
Objection, relevance and vague.
Overruled.
Well, I'm trying to best answer. I've always been aware that his conversations have been reviewed, as I've been the one who's been listening to his phone calls and reviewing his visits.
And
So from the beginning of trial to present.
perfect. So since trial began, are we going back to October 29th, or are we going to January 7th, as counting as when you understand trial began? Let me ask you a better question. When did you start reviewing the conversations of my client, Mr. Merritt?
2014.
When did you start reviewing his conversations that occurred in 2018 or later?
In 2018.
So you've been reviewing them the entire time?
Yes, sir.
And by reviewing your, I understand that the sheriff's department has a database that records all conversations that are on the phone?
Well, it's not the sheriff's department's database. It's Securus. It's a outsourced company.
Yeah. And the sheriff's department has access to such recordings?
Yes.
And if the sheriff's department so wishes to review, then they would request phone calls based on a booking number?
No, that's not how it works. That's one way you can get them, but that's not how I do it.
And then how did you access the recorded phone conversations? Let's start there.
Again, I'm gonna object because we're about talking about a phone conversation.
Overruled.
You just log on to the Securus website.
And so you did that to listen to the phone calls of Mr. Merritt?
Yes, sir. It's practice to listen to phone calls of the suspects.
Now, also, besides phone calls, inmates in the custody of San Bernardino County can have conversations with individuals by person-to-person visits. Would that be fair to summarize it that way?
Depending on the jail facility.
Like,
Yes.
If they're housed in a central detention center, as my client was at some point, the people that meet with them would meet face-to-face through glass and use a phone receiver to speak, correct?
I'm not familiar with Central Detention Center. I know how High Desert Detention Center and West Valley Detention Center do it.
Right. And I don't remember him being up in High Desert, so I'll avoid that one. In West Valley, there is a visiting room inside the unit to where a person in custody is brought to the room where other people could be visiting, and the public meets on the other side of a glass barrier to meet with an individual, correct?
Correct. In the general purpose room, there are it's a visiting area, visiting booth as you characterized it. in the upstairs tier. It's in a common area. It's divided by a glass, and there are telephones on both sides for them to communicate.
Right, and there's probably 6 or 8 different, somewhere in that number, maybe 10, somewhere in that, to where different visitors can meet with loved ones, correct?
Yeah, about that.
And I believe each visit for the telephone to where they can have access is timed. So the visits are timed.
The time is dependent on the custody specialist running the visits. I think they do click off after 20 minutes. 20 minutes is a general visiting time. However, they can just enter their booking number again and continue the visit.
But it is timed.
I'm not 100% sure about that.
And the conversations that occur in that room when they use they have to use a handset to talk to one another, to hear them clearly, correct?
Yes, sir.
And those are recorded.
Yes, sir.
And there's no signs up that say they're recorded, correct?
They're advised when they pick up the phone. There's a recording on the telephone.
And if they do not pick up the phone and talk without the phone, are they advised by a sign?
No.
And did you start to review those visitation recordings for Mr. Merritt with anybody on the public?
Yes, I endeavored to pull his visits.
And when did you start doing that?
Probably December of 2018, I would think.
And just so record's clear, I'm familiar with it, there's a separate area for official visits that do not have the same constraints as public visits, correct?
Yes, sir. There's a probation visiting booth as well as an attorney's visiting booth, which are separate from the area that we were speaking of. Well, it's in the same area, but it's not under the same type of monitoring.
Yes. There's, instead of glass, there's a grate, and people can freely speak to one another without the use of electronic devices.
Correct, and you guys can pass papers back and forth.
Correct. And I rest assured assume that is not monitored by the sheriff's
It
department.
is not. No.
But they are adjacent to one another inside those units.
It's all up in the same second story tier of the general purpose room.
And so when you started listening to the conversations on the phone, let's just say in 2018, were you informing the district attorney's office that you were doing so?
Only if a relevant conversation occurred, because I wasn't doing it daily. If there was something that was of note, I think I would mention it, but I can't think of anything offhand.
So what I'm saying is, you would let them know I'm listening, but if something important came up, you would say, hey, and this is what I heard.
I think there was never an official like, hey, you listen to this. We always listen. That's what we do on our side in the homicide detail. I don't seek their permission or ask for their permission to do so. It's just something we do.
Yeah, and it's not about permission, just you let them know you're doing it.
I believe they knew, yes.
And then also when you started doing the monitoring of any in-person visits in the jail, did you inform the district attorney's office you're also doing that as well?
Again, this would be in the same, you do it the same way you monitor the phone calls, so yes.
When you say the common area, you're referring to the unit to which they were housed, where they don't have free access unless they're led into that area by a deputy and monitored by deputies, correct? It's not like the living quarters.
Right, it's a general purpose room would be the best way to describe it. It's outside of his normal pod or segment where he's housed, but it's an area where they conduct, nurses' visits. There's a nurses' station there. That's where the inmate workers prepare the food to disseminate to the rest of the segments. So, no, he can't freely go there like from his housing unit, but he can't even go to his own general purpose area from his housing unit because of his classification.
Anybody to get to that common room has to go through a secured door, which is controlled by sheriff's staff.
That's accurate.
And then the, inside the common area for the visitor booth for the public, each location has like a short divider that would separate the individuals. That maybe goes back a couple feet.
It doesn't go back a couple feet. It doesn't go back a couple feet. I believe there is a small divider there, but it's
not soundproof.
Oh no.
But there is a slight divider.
Yeah, there's a slight divider.
So you and I are talking in this location and we're in close proximity to the phone. I can't see the person's face on the other side of the glass in an adjacent booth, as lack of a better term.
Not if you're using the phone, no, because the cord isn't that long. If the cord was longer, you'd be able to sit back and see them.
Right. And if you stand back in the room from a public side, you could see everybody's face.
Yes.
Because they face towards the entrance door to that visitation room.
They being whom?
The windows. The windows, like and the people in custody are facing always towards the door, the main door that all the public visitors visit.
Yes.
It'd be like everybody coming in there and the glass being here.
Correct, that's accurate.
At times, did you update the district attorney's office on what you had heard on the public visit recordings that you started listening to in December of 2018?
No, there were only like 9 public visit recordings and none of them were relevant.
In February, did you find some public visits information relevant?
Yes.
And is that when you provided recordings to the district attorney's office?
Yes, sir, I believe it was February 1st, 3rd, 8th, and maybe the 11th.
And when did you listen to the one on the 1st?
On the 1st.
And when did you listen to the one on the 3rd?
On the 3rd.
And when did you listen to the one on the 8th?
On the 8th.
Did you listen to the one on the 11th?
If the 11th is the correct date, it's same day. All of them were the same day. As they were recorded, I listened immediately after I listened to them.
And at any point, you heard something important for the 1st, did you relay any information to any personnel at the district attorney's office?
Overruled.
Yes, I copied all of those visits to a CD and provided them to the district attorney's office.
I understand we received them all in one CD. I'm just after just the 1st.
Well, it would be the weekend after them because the visit was a Friday evening and then there was another one on a Sunday, I believe. So it would have been on, when you're talking the 1st and the 3rd, it would have been what, the 5th? Whatever that Monday was, is when I provided the CD, I think.
The 4th, because there's still a calendar.
That's when I provided the recording. I'm not 100% sure if that's when I burned it to a CD though. That may have been afterward.
And then you kept listening and heard more information on at least the 8th?
There was a subsequent visit on the 8th as well as the, I believe it was the 10th. Or whatever that Sunday was.
The Sunday would have been the 10th, according to the calendar.
I believe so.
And then did you have to provide a second copy of the recordings for that Friday and Sunday?
I provided those to the district attorney's office, yes.
And what date did you provide those?
I think we were dark the 11th and the 12th, so perhaps the 13th, I'm not sure.
In all the phone calls that you downloaded in 2018, did you provide any of those to the district attorney's office?
Yes.
And which ones did you provide from a month standpoint let's start there, in 2018?
I don't recall. There were several CDs, and I didn't burn them. You have to request for the jail to download them to a CD. And so I made the request, but I don't recall what time span that covered.
And
After the first CDs were obtained from the jail and had them made them for you, did you request a second set after that in 2018?
No.
And after you requested those, did you provide those to the district attorney's office?
The first set was provided to the district attorney's office, yes.
And that first set covered what time period?
I'm unsure. I would have to look at the CDs and see the date when it started and stopped, because you're talking about 4 years of him being in custody, and I believe we only requested the 2018, maybe a year back.
Okay.
But I'm not 100% certain, Your Honor.
And when do you think you provided that?
December 2018, maybe sooner.
Okay.
If the CDs we received show they were burned in July of 2018.
Say they were burned. That as far as that's the calls that were on them.
Yes.
Correct. That's not when I requested them to be burned. Right. I think I'm unsure of your question. Can you?
If the CDs have written on them they were burned, I believe it was July 12th, 2018, by district attorney staff, but it's on their CDs. Would that seem consistent with your memory of when you could have obtained them?
Yeah, it's possible. I would refer, if that's when it said it was burned, then yes, that would be correct.
And are you familiar with Mr. Merritt's housing status?
Yes,
He's in protective custody
protective custody segregated.
and ag-sag as well, correct?
I consider ag-seg something different, but PC seg, protective custody seg.
And in the unit he's in currently is Unit 11.
Yes, sir.
In Unit 11 common room, is there not a separate public meeting booth that's secured?
In the general purpose room, or are you referring to a different room?
General purpose. Well,
Right.
upstairs for the visitation.
Right, so the way that's set up for Mr. Merritt's safety is he actually goes into a room where there's a telephone, or he can talk through the glass as he does. And then on the opposite side, on the public side, is an open forum. There's no divider for the public, or no room for the public. They're all in the same general area. But because of his classification, he is in a locked room.
So it has walls and a door, and it's secured to keep him from other inmates if they go up another common area.
Yes, so they can run visits of different classifications at the same time.
And those doors, are they made of metal like the rest of the jail secure doors?
Yes, sir.
And I assume there's a glass door for a custody officer to look in that room to see when the inmate's ready to be moved, or any necessities for security activity.
Yes, it has a window, and there's that whole general purpose room is also monitored by a camera.
And that camera is monitored by staff.
Yeah.
And just to be clear, you're certain that you didn't start listening to in-person conversations till December of 2018?
Yes.
It was after Thanksgiving.
Correct. I believe the last in-person visit he had that's even on file, where he didn't just talk through the glass, is like November 22nd.
Of 2018?
Of 2018, yes, Your Honor, sorry.
And did you review any of the visits from November of 2018
Yes.
and October?
I don't know if there was one in October. I remember the last one being in November. Again, in the entire 4 years he's been in custody, there's only 9 visits that were recorded via the telephone.
And all public visits to an inmate are tracked on sheriff's systems, correct?
Mm-hmm. Yes, sir. Sorry.
So you can look up when there's visits for Mr. Merritt.
Yes, I can.
When someone goes to visit an individual in custody, they generally have to make an appointment. Is that correct?
Yes, you have to make an appointment 24 hours in advance.
Would you get notification of any appointments for visits with Mr. Merritt when they're made before the visit?
No, sir.
So you would have to look up at the end of the day, see if you had a visit.
You have to manually check it.
And are you familiar with the recording system in the common area?
Yes.
Is the recording system set up to where the phones record even if an individual does not pick up the receiver?
No, you have to, the way they're supposed to do it is you pick up the phone and you enter your booking number, and then it's logged that way.
And if individuals do not pick up the receiver, are the phones still recording what they can?
No, sir.
Did you ever monitor conversations live?
No, we don't have that ability.
So any monitoring that you do of conversation would have had to have been obtained or recorded?
Yes, sir.
And just to make sure, were you checking daily just for visits?
No, I wasn't checking daily. I knew his schedule. I knew his schedule, yes.
So he generally had visits the same days of the week?
Usually has a visit on Friday and then one on Sunday.
And so you would wait till after the regular time and check and see if there's any actual visits?
I would usually confirm Thursday evening and then check on Saturday because it's not in the system until 24 hours prior. So
you would check beforehand to see if one was appointment was scheduled,
yes,
and that was easy enough for you to do, correct?
yes, I had access to that system.
And then if you saw there was one scheduled, you'd come back the following day and say, okay, did a visit actually occur? And you would look for a recording.
No, that's not how I did it.
How'd you do it?
I went to West Valley and recorded the visit.
Could you explain what you mean by that?
I physically went to West Valley and ensured that the booth and the visiting area was being recorded, and I waited until the visit was over, and then I pulled the tape.
And when you say it was being recorded, I assume you're talking about in a central command area, like where a recording was made, or are you talking about a recording device was placed in the booth?
A recording device was placed in the booth.
So the recording wasn't through the phone, but through a device that was placed there by the sheriff's department.
A digital recorder placed there by me.
And when you say you placed it in the booth, I assume you meant on the secure side?
Both sides, actually. Not for all of them. I think there's one visit that has a recorder on both sides. There's one that has it just on the public side, and then there's two that have it just on the secure side.
And did you inform the district attorney that you were placing the recorders there to record the visit?
No, sir.
Did you inform them that you had those recordings?
I turned those recordings over after they were conducted, yes, sir.
so you turned them over for the first and the third, you turned them over on the 4th?
Yes, I think that's accurate.
And the visit in November, the 22nd, was that recorded?
That was recorded via the phone system.
So there's two ways to record the conversation. Either if they pick up the phone, you can get that recording, correct?
If they enter their correct booking number, yes.
Or the other way was you started putting a recording device inside the booth or common area to record the conversation.
Correct.
And you started doing that in December?
No, I believe the first recorded visit was manually recorded visit was in January or February
Of 2019?
of 2019.
And how many, there's a total of 9 recordings? Manual recordings?
Yes, sir, if that's what you have.
No, because you said you had 9 visits, so how many manual recordings did you have?
We're talking manual recordings. I think there's 4.
Are there any other recordings that have not been provided to the district attorney's office that you listened to?
I don't know what the district attorney's office has. There are a lot of his phone calls they're all recorded, but to provide them to yourself and the district attorney's office, you have to request them through the jails. I mean, he made calls this last week that haven't been provided to the district attorney's office because they're in the database. It doesn't mean they're not accounted for.
Have you reviewed it?
Yes, I have.
And have you provided any information from phone calls that you have reviewed? Have you provided any information on the details or anything interesting in them to the district attorney's office?
No, as far as details, there was nothing pertinent in them, so they're aware that I was monitoring them, but I don't recall any specific discussions we had regarding details. Maybe just anything, if there was a conversation, it would be, hey, is there anything significant in the calls? No.
So they were taking an active direction in following up with you and see if there's anything new that you've heard that's relevant or important or interesting.
Yes.
And why did you feel it was necessary to put a manual recording device inside the booth for visuals?
Because Mr. Merritt wasn't using the appropriate way of conducting visits, and I believed he was talking about pertinent information relevant to the case.
And so you wanted to hear the conversation he was trying to keep secret?
Yes, I believe his conversations provided important evidence.
Did you have any other personnel assisting you with these actions, or was it just yourself?
I was present for all of the visits. I think I had one of my detectives come one time, but I was the one who placed all of the recorders, retrieved them, and monitored them.
So if anybody else was present or assisted, it was usually with your assistance as well, or follow-up?
Yes, I was present for every single recording.
And just to be clear, I'm not sure if I asked this, when you provided the manual recordings for strike it, did you inform the DA that you were placing a manual recorder in the booth to record visits?
Yes, after I provided them the recordings, they knew that it was via a manual recorder.
And that was after the first time you provided them a copy?
Yes, sir.
Did they tell you not to do that?
Objection or relevance?
Sustained.
Nothing further.
Anything on cross?
How was Mr. Merritt attempting to avoid using the knowingly recorded visit system?
He would speak loudly through the glass.
Was there evidence in this stuff that you listened to or monitored that indicated an intent to do so?
Yes, sir.
What was it?
Mr. Merritt, during his phone calls, stops the person he's talking to routinely to say, hey, we can't talk about this. We'll talk about it on Friday during the visit. And he censors himself, basically.
Is it common knowledge amongst inmate populations that the telephones and the visits are in fact recorded?
Objection, foundation.
Overruled.
Speculation.
Overruled.
Yes, sir. It's also printed in the rules that they're subject. It's not printed in the rules that the visits are recorded. It is printed that the phones are recorded. It's also every time you pick up a phone and have a conversation, they are verbally advised by the recording that that the recordings are subject to monitoring and recording, and it's also repeated at various intervals during the call.
And just for clarification, those are only the phone calls.
And visits,
Okay.
if they use the phone.
Is it common knowledge amongst attorneys that those visits and jail calls are monitored and turned over to discovery?
Objection, speculation, and foundation.
Sustained. Couple of questions. The digital recorder being placed in the room to record, is that something that is normally done with most or majority of inmates?
I would characterize it as a majority of inmates, because there's so many inmates we house for different crimes. I would say no. However, when you're talking about a major crime, yes, it is something. If we feel we are going to obtain evidence for those visits, or if we believe that there's an act to dissuade or persuade a witness, or send someone out to dissuade a witness, we will actively take steps to monitor those visits.
And by we, you mean the investigating officer on the case will do that?
Yes, sir.
As opposed to a regular system in the jail for monitoring all visits?
Well, there's a couple of ways we can do it. Yes, we can contact the jail and we can contact the classification unit and ask them to do it on our behalf, and then the jail will take an active role in doing that. Or we can go ourselves, which it depends on how busy the jail is, honestly.
Okay, and in this case, you did that on your own?
In this case, yes, sir. I was present and I did everything.
And the recordings on the digital recorder that you placed began in January of 2019?
February 2019 may be a better, I'm not sure if there was a visit in January.
Okay. And then are those the recordings that you turned over on February 4th and then February 12th or 13th?
Yes, sir.
And on the digital recordings, there were a total of 4?
Yes.
Okay. And then there were 5 others that were recorded by the jail system?
There was a total of 9 recorded visits within the 4 years he's been in custody that have been recorded on the jail system.
Okay. So the other approximately 5 that were recorded, when were they recorded?
So when I say there was 9 recorded, those are outside of the digital recordings.
Right.
And
okay. So a total of 13 altogether?
Yes, sir.
Okay. All right. So the 9 that were recorded by the jail system, when were those recorded?
I would actually have to pull that up in Securus to see, because it's very sporadic. I know when the last date was, and I know for sure that was November 22nd of 2018, because that was with Miss Jarvis. I don't know when the other ones were. I would have to look at the date. It's recorded within the Securus system.
Okay, so those 9 that were recorded, you reviewed those shortly after they were recorded. Is that right?
No.
No, okay. When did you review those?
I don't know that I've listened to all of the previous 9 within the past 4 years. 4 years. I listened to the November 22nd one, and that was shortly thereafter. It wasn't the same day like with the digital recordings, but it was shortly thereafter. And I would honestly have to re-listen to the other 9 to confirm if I'd actually listened to them.
Okay. Other than the November 22nd, 2018 recording with Miss Jarvis, the other 8, were there anything that you considered to be significant?
No, sir.
Okay. What about the November 22nd, 2018 visit with Miss Jarvis? Anything that you considered significant in that?
The reason that was significant to me is because she subsequently chose not to use the phone system when she had the visit on, I believe it's the February 3rd, 2019. And that was significant to me because I could confirm that she is in fact on the phone hearing the recording that says all visits are subject to recording and monitoring. And then now we have February 3rd, 2019, where she is, in my opinion, intentionally circumventing that system.
At a minimum, not using the phone.
At minimum, not using the phone.
Okay. Other than that, the substance of the conversation on November 22nd of 2018, anything significant in that?
No, sir.
Okay. So those 9 recordings by the jail system, did you provide those to the district attorney's office?
I would have to check the CD that I gave them because I requested everything from the jails, but I did not verify everything on the CDs that I gave them.
When did you do that? That you requested everything from the jail?
I thought it was later. I thought it was in closer to December of 2018. But as Mr. McGee pointed out, if the burn date shows July, obviously it was sometime sooner. I don't recall the exact date though.
Okay. And then in either January or February of 2019 is when you start the digital recordings.
Yes, sir.
And you have 4 of those.
Yes, there's 4 turned over.
Okay. And those are the ones you turned over in February.
Correct.
Okay. Anything further?
Nothing, Your Honor. Thank you.
Okay, you can step down. Any additional testimony?
No.
Any additional testimony by people? Okay, so Mr. McGee, you wish to be heard?
Yes. First, in regards to the statements of my client, 1054.1 is very clear on what the prosecution must give over. And 1054.1b says statements of all defendants. It's not all statements you plan to use. You must hand over just all statements of defendants. The timing of that disclosure is covered in 1054.7. That states that all disclosure must be done 30 days before trial. If material information becomes known after that date, it must be done immediately. Period. And it's not the date that they actually receive the information.
according to 1054.1, they have to provide all materials if it's in the possession of the prosecuting attorney, or if it's the prosecuting attorney knows it's in the possession of the investigating agencies. So once they had information that he was monitoring the calls and monitoring the visitations, they know now he's pulled them and they're in their possession. Because until they're pulled, yes, they're on the secured system. Everybody's phone calls are required. And I think it'd be too burdensome to require the prosecution to pull all those calls of all the defendants at all times. But once they know they're being actually downloaded and used by the investigating officers, then they're required to disclose that to defense. They did not do that here. And I think that was the defense's position is that delay was done for tactical reasons. They were done to let Mr. Merritt continue to discuss matters about the case, discuss matters of the defense strategy, which were done on these calls. And so they had a listening device into the thoughts and process of the defense through this trial, covering ways we'll address witnesses, we will address evidence. They had all this information. They weren't letting us know they had it. That's bad faith. They did all of this when they should have disclosed it immediately so we could remedy the situation and tell our client, as we told him many a time, stop talking about the case. If you have a visit, talk about anything you want. Don't talk about this case. Let us do our job. We both inform every client of that fact every time we have a case and they're in custody. That is a common practice I know of myself and Mr. Moline, and I know inform Mr. Merritt of that. If we would have learned that he was not following our advice, then we would have taken steps to correct that action in a hope to limit the exposure of the defense strategy and defense activities. We would have chose to stop sharing information with our clients so he couldn't share it with others. We could have done many different activities to protect the security of the defense. We were denied that opportunity and prejudiced. By now, the district attorney's office have a full idea of what we were doing with witnesses and during this trial, so they can plan accordingly and act upon it by continuing recording. And the recordings were done secretively. They were not done with knowledge. They were not done with consent. The motion that was filed by the defense and the responses filed by the people dealt with a couple matters. One of them we were citing was the Kelly case. We also addressed the Wyndham case. Wyndham does not overturn Kelly as stated by the prosecution. What it does is it just lays out the same information as by Kelly, saying jail phone calls are always given notice on the phone calls, and so that's an implied consent. Jail visits, they're not known to be recorded. There's no implied consent. If they were trying to express an intent to have a private conversation, or they can have a reasonable expectation of privacy, then there has to be given consent to record that. Based on the testimony of Sergeant Ryan Smith, he even made it clear that they were attempting to have conversations that weren't recorded. They were attempting to have a conversation that was protected, and that was their intent. And they breached that by putting a secretive recording device in the booth as well. So since they had the intent to not give consent to record, and they did anyway, that should be excluded as an improper recording without court order or legal authority. And also it should be excluded as a late discovery for tactical purposes. That is one of the sanctions that is allowed under 1054.5. I want to say it is. There's other ones that are sanctions and different things. If the court chooses to not exclude this information and go for other penalties, we would ask that there be something. Because if there is no penalty whatsoever, then they're just going to keep doing it. We punish defendants for committing crimes and violating the penal code. The same standard should be applied to the prosecution when they violate the penal code. There should be sanctions in some way, shape, or form that the court can devise that sends a clear message to this prosecution team that the penal code must be followed in the prosecution of Charles Merritt.
So The jail recorded conversations, the last of which was November 22nd, 2018. Testimony of Sergeant Smith is there was nothing significant in that.
I have no idea. I've never heard any of those. They were never provided. So I don't know if there's anything significant on those at all. So
There was evidence that there was a CD burned in July of 2018 that was given to you.
that one is only of the jail phone calls over the jail system, not the in-person visits that he mentioned. Those are different. Because there's the jailhouse phone calls. They were burned in July. Those were given to us on February 13th. Yeah, it's an outside call. It's if somebody's calling, collect from the jail to somebody's home. Those are what we generally call jail calls. Those were recorded according to the CD by the district attorney's office in July, I think 12th of 2018, but were provided in February 13th, 2019. They held on to them. I don't know why. I can inform the court, all of the jail calls that were disclosed, we employed staff to go through each and every call. We knew what was on every call that was provided to us, and we planned accordingly. And we were denied the opportunity to review that information before trial. I don't know if they plan to use any of the information or not. I don't have the time to listen to it. We're in the middle of trial. We're talking 90 hours of phone calls. I can't be expected to prepare cases, prepare for witnesses, and also listen to calls that I would have listened to before announcing ready for
Yeah,
trial.
so, other than those calls, Sergeant Smith's testimony is that of the in-person visits, there's only 9 recordings, or 13, I guess.
There's 13 total, 9 secretively, or excuse me, 9 on the system, 4 manually. My recollection.
And those began in January or February of 2019.
The ones recorded on the system, he said the last one recorded was November of 2018. So the 8 others would have been before that. I don't know what's on those. I don't believe those are on the CD we received. I remember the ones being on February were on the CD. I don't have a copy of it here with me. I can't speak intelligently if there was more on there. I haven't had a chance to listen to all of them. I know Mr. Moline has been going through them. And maybe he can speak a little more intelligent on what the contents of those. But again, this is all information that was withheld from us for tactical purposes. And they're required to give it over by September 29th if they had it, or if they knew they existed in the possession of the sheriff's department and they chose not to.
Well, the in-person interviews, particularly the ones that were recorded by the recording device as opposed to the jail system, those didn't begin until February of this year.
Correct.
So those you got within days of them being recorded.
The first and the third were recorded and provided to the district attorney's office on the 4th. The DA should have given those to us on the 4th. That's what the law requires. And then the 8th and the 10th were recorded, provided on the 13th. All of them were provided to us on the 13th. There was a delay between providing us the other items. If we would have known about the earlier recordings that were from November and earlier, then maybe we could have made sure that the February 1st, 3rd, 8th, and 10th recordings never occurred. But we were denied that opportunity to correct the actions of our clients based on the actions of the district attorneys and the sheriff's department.
All right, Mr. Imes, or
It's your motion. You may hear from both of us only because we're trying to pick up on a couple different things. The case law is very clear that it distinguishes between what's in the district attorney's possession and the prosecutor's possession and that of the investigating agency versus the housing agency. In this case, it happens to be one and the same, and clearly they are to be treated different. So there is 4 years, or now almost 5 years, 4.5 years of recorded information in the possession of the Sheriff's Department's housing arm, which clearly the defense is aware of, given his practice as both a prosecutor as well as a defense attorney. Mr. Dougherty re-emphasized the fact that we were listening to his calls, I believe, in October of 2018.
I think it was December.
To Mr. McGee, further putting him on notice that they existed and that we were in fact listening to them. There is no evidence before the court that any exculpatory evidence has been withheld. In fact, what we're talking about is now incriminatory, where it clearly shows the defendant in an attempt to engage in witness tampering to sway the testimony of one or more witnesses. As for any expectation of privacy, the case law is very clear that inmates within a jail setting have limited to no expectation of privacy. They are on notice of the recordings of both the jail calls and the jail visits. And in this case, you cannot, even though Mr. Merritt was conscientiously attempting to avoid recording, he was not creating an elevated expectation of privacy either through his housing classification or the manner in which he communicated with visitors. Because if the court recalls, the visitor side is an open area, it's not secluded. So anything he would have been yelling through that glass would have been heard by not only the visitor, but other visitors within that area. So there is no heightened expectation of privacy there. Consent is not required. They do not cite any case law for that. As for the discovery issue, clearly Mr. McGee is on notice that those exist, and there has been no request for them other than what we have provided on our own volition once they were provided to us. My understanding, and it would have to be verified with double checking the disk, and we don't have ours handy either, but how I understand the system to work is the secure system when you download. So the download that would have occurred and turned over in July would have included phone calls and any visits that occurred prior to that download, because it catalogs them and stores them in the same manner in the same system.
And then when was that provided to the defense?
That would have been on the disk that would have been provided in July, so any visits prior to that July download and providing a discovery should have been included on the disk. But I don't think that we've necessarily listened to every single one of them either. As for discovery of the manually recorded ones, those occurred within a timely fashion of discovery. They were provided to the defense. And as to 1054.1, it says statements of all defendants. It doesn't say all statements of all defendants, and there is no case law authority that says that. The closest you come is the Jackson case, and the Jackson case was a wiretap case. And in that case, the court ruled that all recordings of the defendant on the wiretap fell within the purview of 1054.1 because they related to the actual crimes charged in the investigation of those crimes being charged. It did not extend to all possible conversations with all possible people while he's in a housing setting versus an interview versus speaking with a co-conspirator, etc. These do not fall within that, and there's no indication, I don't think necessarily argued by Mr. McGee or elicited in a testimony, that really any of the other phone calls or visits until we reached the witness intimidation in February really had anything to do with this case due to Mr. Merritt's intentional attempts to not discuss the case in a recorded setting. Sergeant Smith has outlined that process for you and the reasons and somewhat the frequency that it occurs. We have complied with our discovery obligation in a timely fashion. I will note for the calendar as well, the 11th, the court took off at Mr. McGee's request. The 12th was a court holiday of February of 2019. And by the time that the materials were prepared and given to the defense on the 13th, it was timely. Accusations that was intentionally delayed from the 5th until then are unfounded and speculative at best. and therefore we believe there's been no violation of 1054 or any other thing that would prevent the admission of these statements. And I will also note that Proposition 8 abrogated certain admissibility standards, and one of those is that truth-seeking aspect. And if there is even a minor or technical violation in the delay in discovery, the defendant should not be allowed to benefit from that in the sense that he is attempting to pervert justice by swaying the testimony of a material witness that either the defense or even the prosecution had the ability to call with relevant material to that. Therefore, any sanction should be nothing more than delay that would allow the defense time to prepare and deal with the nature of that evidence, although I do note at this point they've had more than 2 weeks to do so. The other is that there is no prejudice in this. The fact that Mr. Merritt has a continual ability to want to talk about his case to whoever, whether it's an ABC reporter who gets a visit in 2014, CNN who does an entire hour-long special with him, or his family and friends who meet with him and acting in contrary to his attorney's advice is not attributable to us, and there is speculative that they could actually remedy that, since they admit that they've told him many times not to talk about his case, but apparently he keeps trying to and wanting to really any listener that is willing to come in the door. So there is no prejudice able to be established other than rank speculation that they think they have control over and could cure Mr. Merritt's insatiable desire to discuss his case and the events of the day. I don't know if Mr. Dougherty has anything to add to that.
No, I think my input would just be regarding the wiretapping allegations. There's clearly a law enforcement exception to that, so long as it was lawful prior to 1968. And my brief details that change in the case law prior to that. There is some, we're checking right now, there's some indication that some of those recorded visits as opposed to recorded jail calls may actually have been on the disc we provided. But I have not listened to them. I believe Sergeant Smith's checking as far as that goes. And again, this is a narrow request that we're seeking to admit one visit.
Mr. McGee, you want to hear this one?
A couple things to address. One, we take exception to the statement that there was witness tampering going on. I think the proper term is we may allege there was witness tampering. The one thing they talked about is there was no, Mr. Ives, you spoke of, there was no exculpatory evidence contained within. That is not what's within 1054.1. It is not all exculpatory statements of the defendant, it's all statements. Also, again, 1054.1 does not put the burden on the defense to request. It says the prosecution shall disclose. They keep putting the burden on the defense to tell the DA to give over discovery. This is not the first time we've heard this argument. I'm certain it won't be the last. The duty on the prosecution is to hand over this stuff on their own volition. It is not the defense's job to instruct them how to do their job. It's the penal code that informs them of their requirements under discovery rules, and they chose not to follow. They also said during their argument that other visitors could hear. Every time I've gone to Unit 11, there's been no visitors, or if there is, there's one. It is not a heavily housed unit with a lot of visitors. It's not like the other units at the jail where visiting happens all the time with multiple people. That unit is a little more secluded, and less visitation has been observed by myself. And he's in closing booth, but the public will be open on the other side. The July 12, 2018 disc, so the court's clear, was not given over in July. That was one of the discs we received on February 13th with the other visitations, so those were received 7 months late. And lastly, the protections of Prop 8 does not allow the DA to just get in any evidence they want. That is not what Proposition 8 says. It still falls within the restrictions and guidelines and punishments and exclusions as listed in different parts of the Penal Code. 1054.5 survives Prop 8, and that is still exclusion is still a proper remedy for this court. And the timing under the wire statute says it was lawful in 1968. Once a client is represented by counsel, the law enforcement is forbidden from surreptitiously recording statements inside a jail cell. They cannot do that. That is still the law in the state or in the United States. So once the right to counsel is attached and he's been arraigned, the sheriff's department is precluded from secret recording his jail cell conversations without notice. And this is the exact type of conversation that was done. And so Prop 8 doesn't help them. The Penal Code Section 633 does not help them. This was all done in violation after he has retained counsel without notice. And so it all should be excluded.
All right.
Well,
So,
I'd like to clarify, disclosure does not mean physically handing over. There's numerous case law that points to the fact that giving knowledge of the existence of stuff is satisfactory of that disclosure requirement. And once again, misstating 1054.1 to say it means all statements of the defendant is not what it says. It says statements of all defendants. That juxtaposition is misleading for the record. And if the court wants to exclude all the jail calls turned over on that July disc, feel free, we're not using them.
all right. So, a couple of things. Number one, it is, I think, clear that case law in California is that there is not a reasonable expectation of privacy within a jail facility. So defendants do not have a reasonable expectation of privacy with regard to telephone calls, jail visits, and so forth. Obviously, that does not apply with regard to visits with attorneys, experts, investigators, things of that nature. But phone calls, family visits, friend visits, I think the case law is clear, there is not a reasonable expectation of privacy. So I don't think there is anything improper in the recording of visits that the defendant has, whether it's done over the jail phone system for where inmates and visitors talk, or if they're somehow otherwise recorded, whether it be part of the jail system or an additional recording device that's placed there for that purpose. So I don't think there's a violation in the recording of the information. I think 1054 does require the prosecution to provide all investigative statements of a defendant. As Mr. McGee pointed out, it would not be reasonable to require every phone call and every visit of every defendant to be recorded and turned over as part of discovery. So I don't think that they're required to do that on a regular basis. If it is monitored, and if it is someone, either the investigating officer or a prosecutor, decides, well, wait a minute, we're getting some relevant information here. The defendant is making admissions, he's attempting to sway or interfere with witnesses or doing something else that we think is relevant, then again, of course, that needs to be turned over. So we have two sets of material. One, we have the normal routine recording of jail visits, the last of which occurred in November 22nd of 2018. Sergeant Smith said he did review those on a somewhat regular basis. He determined there was nothing of value in those. Made no reports, made no notes, did not turn over any information to the district attorney. Although apparently there was a download of some, I guess some of those were actually recorded and turned over to the DA, I guess in July of 2018.
If they're on the same system, they could have been. I don't know the details of how that worked, because the recording of that system started after I left the district attorney's office, and I've never received them before. So I don't know, I don't have any personal background on how that is all managed and provided.
At any rate, there was, I think, first of all, everyone is aware that jail inmate telephone calls and visits are recorded. I think defendants in custody know that, particularly defendants who may have been in custody previously. Certainly, any defense attorney knows that, and certainly prosecutors know that. So that's not a secret. So we have a situation where at first we have visits being monitored on a regular basis, the same as any other inmate visits are monitored and recorded. Nothing of significance is noted in any of those. It's not, no reports are generated, no notes are made, no information provided that, hey, the defendant is saying this might be important. So I don't see any discovery violations there. Then we get to the recordings that began in apparently February of 2019. Those are not the routine monitoring. Those are a situation where now the investigating officer, Sergeant Smith, has some reason to believe that there may be incriminating information in those interviews, in those visits, and believes that the defendant and whoever is going to be visiting are going to evade the routine recording system that would have picked up those conversations if they used the phone line for their visit. And so he decided to place a recording device there to obtain those. And I would agree that discovery of that is required. Court finds that discovery was provided on a timely basis. We had recordings done February 1st through the 3rd, turned over to the DA on the 4th, and then recordings February 8th through the 10th or 11th, turned over to the DA on the 11th through the 12th, and provided to the defense on the 13th. So, court finds that that was timely provided to the defense. And certainly, as pointed out, counsel are aware that visits are recorded. Counsel are aware that other inmates may attempt to gain some benefit for themselves by either obtaining information from a higher profile defendant or overhearing information and using it to try to get a deal. And attorneys, of course, tell their clients, do not talk about the case with anybody. Don't talk about it with any inmates. Don't talk about it on visits or telephone calls because they're monitored. And Mr. Merritt apparently, nevertheless, still does. So I don't, whether those recordings would have been turned over on the 4th as opposed to the 12th or 13th, I don't see that that would have changed anything or been, have any relevance. So the court finds that, number one, there's no expectation of privacy with regard to jail visits or jail phone calls. So there was no violation in the recording of jail visits and jail phone calls. Court further finds there is not a requirement to turn over all routinely recorded jail phone calls and jail visits that are done with every defendant to every defense counsel to review. A requirement to turn those over only arises if at some point someone decides there's something relevant that they may want to use, or obviously exculpatory information. And that did not occur with the routine recordings that were done through November of 2018. Court finds that the investigating officer had reason to believe there would be relevant information in subsequent interviews beginning in February, and took additional steps to record those if steps were done by Mr. Merritt and his visitor to avoid the existing jail recording system. Court finds there was a requirement to turn those over as discovery. The court finds that they were provided in a timely fashion. So the court finds there's no discovery violation with regard to those. Therefore, the motion to exclude the recordings or evidence of the defendant's statements in the February 2019 visits is denied. The second issue, the people in their motion indicate there's two areas that they want to go into. One relates to a visit between Mr. Merritt and Catherine Jarvis on February 3rd of 2019, in which there is a discussion about a waterfall project and not getting paid, and telling her to remember that he and Joseph were going to split the loss if they didn't get paid.
Just so the court's aware that these are just excerpts. I have a full transcript.
Okay. Well, at least from the excerpt, I don't really see the relevance of it at this point prior to Ms. Jarvis testifying. If Ms. Jarvis testifies about that particular incident and somehow that has some relevance, then I think that could probably be utilized for impeachment purposes. But this discussion about the waterfall and not getting paid and how they were gonna split the loss and what was gonna happen with all regard to that, I don't see the relevance in that.
Well, the relevance would be, Your Honor, in particular, Mr. Merritt urging her, after she remembers only a little bit of it, to remember more. You're going to be asked this specifically.
And I understand that, but
That, from our position, is clearly an attempt to fabricate evidence under, in particular, California 371. He's talking to somebody who he knows or he actually believes is going to be on the stand, telling her what to say when she's asked her questions, and telling her background that she doesn't necessarily know.
okay. But if he's doing that on something that's not relevant, I mean, I understand your argument that
Well,
if he thinks it's relevant, and if he thinks it's gonna be important, and it's, she's saying, well, I don't really remember that, and he's trying to convince her, you gotta remember this, you gotta say this.
well, I'm glad the court came around to our position that it is irrelevant, because there was numerous photographs, or at least one photograph, an attempt to photograph showing what is this waterfall, what is this waterfall. We objected numerous times that none of this is relevant, and the court overruled our objection. So clearly the defense, or at least the defendant, does think it's relevant. And I don't think that really matters. I think what matters is the defendant attempting to materially alter someone's testimony.
We have evidence of the police doing the same thing. We can go down that road and spend 2 months doing that.
Well,
I'm not finished.
go ahead.
Additionally, that particular waterfall was on the email that Joseph sent to the defendant on February 1st, as you still owe me this additional money. So I think the defendant attempting to tell her what to say about that particular waterfall is relevant, because our position is he was in deep debt to Mr. McStay. And him persuading her.
You said, was that in evidence, the February 1st?
Yes.
Yes,
So-
the email came in with Detective DeGaulle and was cross-examined by the
This
defense.
was also shown in my opening statement. In him saying, when you get on the stand, you're gonna be asked specifically, do you know about this? Yes. Is relevant. Well, I don't think the fact that the waterfall is relevant, now that it looks like, and all of that, but certainly the business dealings that he mentions here would be relevant.
So how do we know that this waterfall that's referenced, it was a big waterfall at some restaurant? Joseph got stiffed for it, $32,000. There's gonna be a lawsuit. If he lost the lawsuit, we were gonna split the loss. How do we know that's the same waterfall referenced in the February 1st email?
Because at the bottom of page 1, he references the Provencio restaurant in LA.
Yes.
The email references Provencio. And Mr. Skada also said he had to fix it.
You have the February 1st email?
Oh, we don't have the exhibits here, do we? If I had internet access, I could pull up a copy.
Do you know what exhibit number it is?
Oh, what's that? That I can look up without being connected. would be 419, email from Joseph McStay to Charles Merritt, 2/1 of 10. It was used on January 14th with Detective DeGault.
419, can you get that? All right,
Let me see if I have a digital copy in my offline account, and if I do, I'll give it that way, otherwise we're gonna have to. Here it is. I can't print it, but I can show it.
okay.
I'll show it to council. Scroll down by either touching or hitting down.
Scroll down using this. Oh, okay. Okay, yeah, I remember this being referenced. This was just kind of like an accounting that there was basically a difference of $15,000 between what was paid and what was owed.
No, it's actually more than that, when you include the Provencio and the other projects.
All right, right now, I don't think there's enough context for that to be put on in the DA's case in chief, both on relevancy grounds and evidence code 352. I would sustain those objections. It may obviously become relevant if Ms. Jarvis is called in to testify about that and link it to statements about what was owed or what the status of the accounts were between them. And at that point, then I think it would be relevant for potential impeachment. The next area deals with I guess it's still on the same date of February the 3rd, 2019. You're talking about the cell phone reception in the clubhouse where they live. That's cell phone reception is bad. And then they talk about the dates of February 4th and February the 8th. Starts talking about February the 8th. I called you to find out what I did on the 8th, and we heard that recording with Detective DeGault during his interview of Mr. Merritt. And he was asked about his activities on the 8th. He said, I don't really know. Let me call my wife. He calls Ms. Jarvis and asks, what did I do on the 8th? What day was that? And they get cut off a couple of times. So they discussed that. And he tells her we're going to play that excerpt to prove the bad reception.
Well,
Wait. And he goes, okay, you were at home at the time, and you're going to testify about just that. And that's very important because the February 4th call, remember they were telling you Chase's truck was seen at Bonsall or at Joseph's. They said he wasn't home. Remember that? And you tried to call him 5 times during the evening. You wouldn't be trying to call him if he was home, would you? There's then something, rather than transcript, there's just kind of a summary of Mr. Merritt telling Miss Jarvis he was home. Miss Jarvis says she knows that's what she already testified to begin with. And then the defendant says, well, you haven't testified yet. You're going to testify. That's not what you said before. And Jarvis says, I know what I said before. And Merritt says, well, no. What they're going to say is that you said he wouldn't be home and calling you. Well, I was being jumped upon by 2 detectives. Just tell him straight up, I didn't know what the hell was going on, and then Jarvis interrupts. They asked me specifically, he wouldn't be calling you if he was at home. You wouldn't call me if you were home. You might call me from the clubhouse. Merritt then continues, yeah, but rare. That's important when you get on the stand because you would have been calling me a half dozen times trying to reach me. And then what happened, the way I now visualize that day happening now, that I stepped back and looked at it at all the events. I came home, I took the kids over to watch a movie. You got home a little later, I think. And Jarvis says, on the 4th? Merritt says, huh? Jarvis says, on the 4th? Merritt says, it was a Thursday. It was a Thursday. So you would have been at the school. So I probably had one of the other kids, or I was in the computer room or something. You were trying to reach me. For a time I came back down to the house, laid my phone on the counter, phone rang, you saw it. Obviously I didn't. I never remembered that phone call. Ever. I still don't to this day. So that seems like it's a specific conversation about predominantly February the 4th and trying to establish he was at home but didn't have his phone and didn't have phone calls.
I can inform the court the interview that Ms. Jarvis had with law enforcement. That's what she kept telling me. This is a review of the conversation. And the officers kept telling her, that can't be right. You're wrong. He wasn't there. She's like, no, he was there. I saw his phone. She has said that since February of 2010. And then they started trying to trip her up and say, well, what about this? And they're trying to change her testimony and change her statement. They were trying to realistically manufacture evidence that he wasn't home. And she was very clear in February 2010. She's been very clear in all emails she's made with other people. She's been very clear in San Bernardino. He was home when that phone rang. I saw it ring, and I wondering why he wasn't picking it up. So this is not Mr. Merritt trying to convince Ms. Jarvis what to say. This is a rendition of the statement she has said since day one. And even though the law enforcement tried to get her to change that story, I shouldn't say that. San Bernardino Sheriff's Department tried to get her to change that story. She stuck to it. And she has even under threat of arrest. They were threatening her, if you're going with this, then you're an accomplice. And we're gonna arrest you too. She still held her ground. That's what happened. And that is what the conversation was. It was not Mr. Merritt trying to tell her what to say. It's a reminder of the recorded conversation, the contents of it.
All right. Well, that may be, and I still think that conversation is relevant. If that conversation is played, however, for that inference that Mr. Merritt was trying to get her to say certain things, then the defense, I think, would be able to put on the earlier statements to show that Ms. Jarvis didn't need to be reminded or convinced of anything, that she had said that from day one and continued to say that.
Well, can I be heard?
Sure.
Couple things. One, I take it the court is presupposing an objection by the defense on relevance grounds 52. That motion has been made. Two, this court specifically found that evidence of Dan Kavanaugh's business relations with Joseph McStay was probative, and the prejudicial effect did not outweigh the probative value, substantially outweigh the probative value. Knowing that the people's theory of the case is that the defendant was in deep debt with Joseph McStay. People have now presented evidence of a statement of Joseph McStay saying, "You owe me for a project." And now the court has some indication that the defendant is trying to make her remember things and saying, "You remember this. Of course you remember this." So the analysis is the same. I mean, if they're going to be allowed to say the detectives pressured you, then under 356, I think we're entitled to say, well, didn't he pressure you to talk about this prevention thing? Because the analysis is really the same.
I think it depends on what she says. If she gets on the stand and says,
I mean, I don't even know that she would have foundation to say, other than hearsay, what the provincial deal was. I mean, at most, all she can say is, well, Mr. Merritt told me that X, Y, Z, which would probably be exculpatory to Mr. Merritt, which would be hearsay.
Well, there's been plenty of that in this case. Also. Second of all, that's not the focus. The focus is, what is the defendant doing? He's trying to alter her remembering of something. And that should be the focus. It's an attempt to alter the evidence in the case, potential evidence in the case. And that's what 371 is focused on. And the trier of fact is free to consider all of those other factors. But both of these topics should be allowed to consider both of them, because it's not really her and what she knows, it's him telling her what she knows. Okay? And the fact that the detective said, "You remember this 828 phone call, but it doesn't show up on his phone records," okay, they can go into that if she testifies. Whether she testifies or doesn't, I don't think it changes the analysis. The analysis is an individual trying to prevent recording so law enforcement doesn't know, and I'm going to tell the witness what they're going to say when they testify.
Okay, with regard to the February 4th and February 8th issues, I agree with you. So I would let you put that on.
And I'm just trying to understand the court's analysis with regard to the financial transactions of Dan Kavanaugh suddenly being relevant under 352, surviving the 352 analysis. But the defendant's attempting to refresh someone's recollection, I put that in air quotes, about his business dealings with Joseph is not relevant.
So, I mean, I looked at that email, and it's just kind of like a balance sheet of how much was paid, how much was owed, how much is still owed.
Right, so the overpaid amount is $15,000, I'm sorry, I don't mean to interrupt the court, I apologize, plus $8,800 for Levine, plus $19,000 for Provencio, for a total of $42,845, plus the $15,000.
Okay,
So Provencio, not to mention David Cicada testified about the Provencio project and how he had to go back and redo it. This is all part and parcel of the defendant's, what he does with business with Joseph McStay. And now he's trying to get somebody to explain for him what the business deal is. And that should be the focus, is him trying to influence somebody to say, no, this is actually what the business deal was. And he also admits in the same statement, I don't know if I put it in the excerpt, that he did owe Joseph money, that he was going to make payments over a period of time.
I can inform the court, or support the court, that if Ms. Jarvis testifies about Provencio, then it could be used for impeachment. Otherwise, they want to just bring it in for character evidence. And
I mean, I understand their argument, it's not character evidence. If a defendant is,
influencing a potential witness about something they're not going to testify about, then if the actual statement's not before the court for impeachment, then it's just character evidence. It's a bad act. And that's not admissible. So until it becomes relevant, as the court identified, then it should be out because it's not really relevant to anything. And I think the court's on the right track for that, and that's why I think these decisions are distinct in that if Ms. Jarvis is called to testify and she talks about the 4th and the 8th based on her personal observations, then impeachment or possible impeachment is fair game.
well, I think the conversations between Mr. Merritt and Ms. Jarvis regarding February 4th and February 8th, I think are admissible in the people's case in chief. That I think there is certainly an inference to be drawn from that he is providing a scenario to make sure she's on the same page with. Now, that may be refuted by the defense to say, no, he didn't need to do that because Ms. Jarvis was already on that page from 2010 forward. And here's what she said in 2010, here's what she said all the way through.
And this is without her testimony. They could just play the tape.
Correct.
And then we can play the tape of her other interview without her on the stand. If we have proper foundation through the officer that did the interview. To refute it. No, we're just waiting the groundwork of how evidence comes in.
No hearsay exception for that.
Yeah, the prior inconsistent statement.
She hasn't testified. It's inconsistent statement.
Yeah, the purpose of the conversations between Mr. Merritt and Ms. Jarvis is not Ms. Jarvis's statements. The relevance is the defendant's statements to Ms. Jarvis. You need to say this, you need to remember this, they're going to say this, you say this. So
Under 371, if the defendant tries to create false evidence or obtain false testimony, that contact may show that he was aware of his guilt. If you conclude the defendant made such an attempt, it's up to you to decide its meaning.
right, and I understand the defense argument is he's not trying to create false testimony because that's exactly what Ms. Jarvis had said since 2010.
But he is with regard to the Provencio, where he says, okay, you need to remember, if you're going to be asked specifically, do you know about this? Yes.
I don't see that having.
And in addition, the owing of the money, the admission that he did in fact owe the money to Joseph in that same report. I would invite the court, since we're getting close to lunch, we can come back at 1:30. It's a short audio. The court will play the whole audio. and read the transcript and the court can decide. Because really what we're doing is, I put excerpts in just to give the court an idea of where we're going, but it's a longer transcript.
Of course it is.
And I think you need to hear the defendant's voice and intonation to make the decision
It's only 9 pages.
as to both of these issues.
Okay. I think the problem I'm having with the Provencal evidence is number one, that one email doesn't make it, I don't think it makes it clear that the defendant owes that money, and part of the defense is now going to be, no, I really don't owe that money.
But the defendant talked about the email in the Duval interview, but he didn't mention the 2+ categories.
He talked about the email in the interview?
Yes,
I mean, in the
if
visit?
I may, he provided this email to DeGaulle during that interview. During that interview, he attempted to minimize and characterize as, no, we're in effect even. is the word.
Right, I remember that.
But that email belies that as inconsistent. And I guess I keep chirping in Mr. Dowdy's ear, and I have to apologize for it, because the other issue I'm having is the court has conceded that the inference of the February 4th conversation is to get on the same page. I'm not sure how that logic doesn't apply to the defendant's conduct about the waterfall of getting them on the same page. And if the logic applies to one, it should apply to both. So I'll leave it at that.
Let me listen to it, and all right, so we'll come back at maybe 1:15 or so.
Okay.
You're in charge.
We were dark today and after we just thought, so.
So you want to come back?
It's about 9 minutes, we can start it now.
It's like 20 minutes.
Just 9 pages.
Well, if you leave it with me, I'll listen to it during lunch. We can, then at 1:30, I will have already heard it.
And Ron, did you print it to disc already as an exhibit? You have it as a disc?
I gave it to you. That was what I dropped off with you yesterday, and I said I'll just leave this here. So it should actually be, it wasn't marked, but I think I don't know if you left it in Department 1.
Yeah, I think it.
Okay. Yes, there's a transcript as well. I left all the transcripts there.
You have something I can play it on?
Do they not give you a CD drive on your computer?
There is one. I've listened to things. I have to basically put my ear up against the speaker
I have
to
headphones.
barely be able to, I don't have headphones.
I do, if you want to use mine.
You're gonna need headphones.
Yeah, you will need headphones.
Here you go, here's some headphones.
That might help.
I have.
Really? Okay, well, maybe that'll work.
Here's this back.
Okay, well, if we can get that, if I can listen to it with the transcript, then we'll come back at 1:30 and I can say I've listened to it, and maybe that'll give me a little bit more insight. I mean, I remember
Oh, yeah.
DeGaule's interview with Mr. Merritt, and I remember that being discussed. And I remember DeGaulle saying, well, you owed him a lot of money. And Mr. Merritt saying, no, not really. Here's this email, he paid me, I paid him, and, you can see it's almost even, and,
No, what he actually says is, after these projects, Joseph's gonna owe me $11,000.
yeah.
But the math doesn't work up with the email.
Okay, all right. But I'm still not seeing the connection of telling Jarvis, say, remember this about Provencal. Especially when she probably can't even testify to it. I mean, I understand that what you claim to be significant is what defendant is saying to it. But, let's suppose he was saying, now remember, I was wearing my brown suit on February the 1st. And let's say that has nothing to do with anything, but he's telling her that. Okay, he's telling her to say that, but who cares?
But this does have something to do with something.
Has something to do with a lot.
Has something to do with a lot.
All right, I'll listen to it.
Should I say that too?
You want to try and make it an echo?
No, I'm good.
Okay.
You want to do it?